Henshaw here again for the Constitutional Crisis Channel. Today's subject is the quote-unquote right to assistance of counsel that the government wants you to believe you have, but trust me, you're going to find out quite differently here. Now, this all starts out and it goes to my issue of the 14th Amendment and meshes beautifully with state versus territory. We'll get more fully into those later. Point here is that what they think is the right to counsel, quote-unquote, only applies through the Due Process Clause of the non-existent 14th War Amendment. You use that counsel, and now they're going to nail you when they get to the Supreme Court, if not before, because there's a maxim of law that says he who accepts the benefit must bear the burden. In California, I think that's codified at Section 3529 of the Civil Code, but don't hold me to that right now, but it's really near that section if it isn't. So you agree to that, and you accept the burden, which in this case means you stipulate to the jurisdiction of the trial, quote-unquote, court, which it can get in no other way. Simple as that. Now, the case in point here, when you say I say the Bill of Rights doesn't apply to the states, not me saying it. It's that iconic legend of Harvard and Yale, Chief Justice John Marshall, who said it in 1828. And note the time frame, because this is the time when a lot of the framers of the Constitution were still living and everybody knew what the hell was going on. They couldn't lie about stuff like this. And the preamble to the Bill of Rights, bet you didn't know it had one, and it says right in there that it was designed to apply to the federal government, not the states. That's what Chief Justice Marshall said. The case is Barron v. Baltimore, B-A-R-R-O-N, v. Baltimore, B-A-L-T-I-M-O-R-E, 7 Peters 243, which I believe translates to 32 U.S. 243. Case has never been reversed. And I've looked at this one closely because everybody tells me it has. No, it hasn't. You look in Shepard's, and we get to our videos on legal research. I'll explain all this to you. But Shepard's is a terrific set of books, and now it's online. And they go through and look at all the cases that the courts decide, and they look at the cases that they cite within these cases. And they put them in all these books. And you can get a lot of notations there. The ones you want to look out for are a large capital O, which is overruled, or a small s, which is superseded. Barron doesn't have any of those, and it shouldn't. It's the case that supposedly overruled it, Dowry Map versus State of Ohio, 367 U.S. 643, one of the worst presentations of a case I've ever seen, for what it's worth. And on both sides, and I believe this was a 5-4 opinion, I'm almost sure it was, and those you want to look at closely and read the dissents. You'll learn about that in legal research too when we get there. Neither side even mentioned the case Barron v. Baltimore. That's a strikingly odd way for the court to reverse a decision of such magnitude and of such standing, 130 years at the time. Doesn't happen that way. They don't do it. I don't believe it. What I do believe is state versus territory. What they're not telling you behind the scenes is they're applying the Bill of Rights not to states, which is they're not permitted to do, but to territories, which the states have become. And you're going to get a lot more about that one down the road too, but that's what I think is going on here. But they had a series of cases, and I'm going to try to get some ostensibly private papers if I can, especially from Justice Douglas and Justice Hugo Black, who were on the court at the time, because there was several cases where this issue was bitterly fought within the court, and a lot of their internal memos you don't see that flew back and forth, and they may be discussing the very issue of state versus territory. The big one is Dewey Adamson versus California, which I believe is 332 U.S. 46, and Dewey Adamson found his ass in the gas chamber when he lost this case. About 5-4, and the court said, sorry, the Bill of Rights doesn't apply to the states, therefore your rights couldn't have been violated. And there's a whole string of these cases. Wolf v. Colorado is another one, 338 U.S. 25, where they discussed that. That's W-O-L-F, just one F in this one. And just a string, and Albert Twining versus New Jersey, T-W-I-N-I-N-G, 211 U.S. 78. And that one, by the way, was the right to not incriminate yourself, and Twining lost that case too. Now, there have been cases later that, as I say, appear to apply the Bill of Rights, but that's not what's going on, and we'll get much more into that in the longer videos. You're going to love it. In any case, the other problem you have is that you use an attorney. Guess what? He's an officer of the court. not only does he owe them his principal, if not sole, allegiance, he can't appear there without the permission of the quote-unquote court. That's jurisdiction. It's a general appearance. That's why they want you to do it. And you see all this crap like on Law and Order all the time, and you see the arraignments go on, and the judge says, "How do you plead?" to the poor bastard who doesn't know any better, standing there with his attorney, "Not guilty, Your Honor." Case over. That's it. I mean, once you get jurisdiction like that, unless you can undo it, and you can if you know what you're doing, but you never see it on TV. So you have that problem. And then the other thing you have is in their so-called mandatory public quote-unquote education system, you don't learn jack squat about this stuff. I didn't 50 years ago. And they just don't teach you the Constitution, laws, and history of the United States. So you have no way to know any of this. That to me is fraud, deceit, and even treason on the part of the entire system to put you in a situation like that. That's what I'm trying to fix here more than anything. So then you get all these condescending cases where the court says later that the accused is greatly in need of the guiding hand of counsel at every step of the process, making it seem like you're getting a fair trial here. Not so. That to me is a qualified apology for the Supreme Court having put us in that position to start with and doing the best they think they can to fix the problem they created. It's exactly what it is. And you get into some of these cases, and I don't have one on the top of my head here, but I have read opinions in the Court of Appeals where the attorney for the accused basically slept through the trial, and the Court of Appeals sustains a conviction. We have no problem with that. He had a fair trial. That's what they call the quote-unquote right to counsel. Not where I come from. Not at all. So, and then you get into, and you find out, by the way, in later cases, and there's one called Ford versus United States, 273 U.S., I believe it's 598, where the court talks about this issue quite a bit. And the fact that you have to go in there and challenge, without an attorney. If you're going to raise jurisdiction, you have to do it without an attorney, and yet we don't have the education to be able to do it. Another less well-known case, and it comes out of the Federal District Court on this occasion, is United States v. Johnson, 76th Federal Supplement. That's the District Court, 538. And the court said right in there, in order to assert your rights and do it timely, you have to be what they called a quote-unquote belligerent claimant in person. And that's exactly what I am. When I get there, I'm as belligerent as I can possibly be. That's what they tell you have to do. I'll take them at their word. So this stuff, and oh, by the way, the California Supreme Court ruled, and this is in the late 1950s, I believe, in a case called People, quote-unquote, versus Teale, T-E-A-L-E. And I believe the site on that is 38 California Report 2nd, 167. I may have to amend that with the notes that are going to be in this, below this video. You'll see it. If we make a correction, that may be in there. It was reversed. It was so bad, it was reversed by the Supreme Court shortly thereafter in a case called Chapman versus California. And that's 386 U.S. 18. But the California Supreme Court reversed because he had been denied counsel. There wasn't any question about it. But the Supreme Court politely said, well, it's no big deal because the evidence was insurmountable. He was going to be convicted anyway. His rights could not have possibly been violated. Even the Supreme Court couldn't buy that. And they reversed it. I mean, that's how bad this is. They consider that harmless error under the California Constitution, Article 6, Section 13, which did not exist in the Constitution of 1849, which is why I used it. No such thing as harmless constitutional error. Now, there's no right involved here, so they have a point, just not in the way they think they do. But this is what you go through with this crap. I mean, and you take their counsel, and you're at your own risk. I mean, sometimes you luck out once in a while, but I wouldn't want to put my last dollar on it. Because you find yourself out there in 10 foot, and who knows what happens to you when they get you in there. We'll talk more about this one later. Thank you.